is kind of on the guardianship side. So I'll probably be talking a little bit more about that because I have a lot more examples or stories to tell in the time that I have. I'll try not to go over. And Lindsay, if I do, just yell at me or mute me or
Oh,
cut me off.
we'll do it. Yes, it is.
Okay.
It is being recorded. I just saw a question, so we are recording this, and we will leave it.
Okay.
We'll let Trey talk, and then we will leave probably about 10 minutes or so for some Q&A for Trey.
Okay. Yeah. So I'll start off with SSI, and I think today we're kind of focusing on SSI for minors transitioning to adults. And in general, the Social Security Administration has a myriad of programs, one of which is supplemental or SSI income for folks that essentially have limited income, limited resource, and are disabled, blind, or over the age of 65. For a minor, the administration is going to look at the minor's disability, as well as the minor's resources and income, if any, and there may be a portion of the parent's resources and income that the administration will look at as well. The calculation of what portion the administration is going to look at in terms of determining a minor's eligibility is fairly complicated, and the little bit of research that I did before this didn't really produce a clear answer. But I would imagine that the Social Security Administration has a ton of publications on how they go about calculating the eligibility for a minor. So, keep that in mind when you have a child and you're going to apply for SSI for that child, that a portion of the parents' resources and income will be considered. And they've got a good chart online, and it's partly based on how many people are living there, if there's a step parent living there, if it's a single parent versus it's dual parents, and how many children are living in the house, and how many ineligible children are living.
Thank you.
Pleasure.
Thank you. So yeah, so the big consideration for SSI transitioning into adulthood as well is again, going back to the I guess there's three aspects to consider. There's the medical side. Is the person suffering from some type of disability, blindness, to qualify, as well as the financial side. And transitioning into adult, the financial side can then be broken down into two categories. So you have, on the financial side, to determine eligibility, you're going to look at resources and you're going to look at income. So resources are going to be what essentially the child has in the bank, the cash, assets, and any real estate that might be owned. And so the resource cap right now is currently $2,000. So if for some reason a minor were to receive some type of I'll give you an example. So sometimes we have minors who receive inheritances from their grandparents, or they may be entitled to some type of personal injury settlement. If they receive that outright at the time that they turn 18, and let's hypothetically say that it's $10,000, if they receive that outright, and it goes into their individual name, then they're not going to be eligible for SSI, because SSI is going to say you have too many resources. And Katie will talk a little bit about this, but there are ways that we can structure that to put it in vehicles that the administration will not count those assets as resources. So kid turns 18, if their assets, resources are below 2,000, then we've met the resource limitation. And then we also consider the income side. And typically with disabled children who are turning 18, they are unable to work, and there is no income coming in. But if there is income coming in, I believe that the cap right now is just the amount of the SSI benefit rate. So, and that's, I don't have that number off the top of my head, but I think it's in the 783, 794 range per month. So what the administration will do is they will look and see what the income is. And let's say that the...
Hi, I have an appointment with Cody. Jamie Wilson.
Okay, we're good.
Okay. But let's just say hypothetically that the person is making, you know, $300 or $400 a month in what's called countable income. The administration is going to look at that and say, okay, your countable income is $300 a month. We're going to subtract that from your benefits. So that 794 is going to be reduced to about 494 because of that countable income. And kind of let me step back a little bit and go back to the medical criteria. That also changes for a minor who is becoming an adult. So for a minor to determine the disability, SSA determines or must determine that the minor's disability is expected to last at least 12 months that results in marked and severe functional limitations. They have medical professionals that will make that determination or will rely on the proof presented by the applicant. The determination for an adult is the impairment must result in the inability to participate in any gainful activity. So based on that difference, the level of disability must be higher for an adult. So that is a distinction between determining eligibility for a minor versus determining eligibility for an adult. So just keep that in mind when you're going through that process. Now, jumping back to the income side, I want to give you guys a couple examples that I've dealt with recently. One of which is, you'll probably hear this term a lot, it's called in-kind maintenance and support. So what happens is disabled child turns 18, they're still living at home with mom and dad. If that child is living there for free and mom and dad are buying food, then SSI is going to come in and dock the eligible adult's income by, I think it's just an automatic 1/3. So what we do to avoid that is we just draft up a simple lease agreement between the parent and minor, or parent and adult now, that says that for a one bedroom house, we're going to charge $400, and she's paying for her own food. That generally is sufficient to present to the administration to say, her income, or his or her income, should not be docked because she's paying for her room and board, and she's paying for her food. Now you kind of have to, normally it works with every caseworker. They see that and they say, okay, that's great. You know, she's paying her fair share of expenses and food and all that. We're not going to dock her pay. I've had some caseworkers kind of get crossways with the applicant in terms of, you know, asking a little bit more about, well, what's your mortgage, what's your property insurance, what is your what's the property taxes, and they actually try to come up with a, you know, if there's 4 people living there, then they try to come up with, well, the person should be paying, you know, a quarter of the expenses. So I say all that to say, just keep that in mind. To maximize the benefits for the applicant, you'll want to be aware of that in-kind maintenance and support, and that can typically be resolved through just a lease agreement between the child or the adult and the parents. And then the second one is going back to the resources issue. We had a child that was entitled to a personal injury settlement. She received it when she was a minor, and we put it into a special needs trust. And for whatever reason, even though we had a determination at the state level that this special needs trust was a valid D4A trust, it's the federal code that it's tied to, even though it's a valid trust, we're still going to count it as at the federal level, the SSI level or SSA level, we are going to count it as a resource. So that we're going to have to appeal that decision, and so that's another kind of practice area for us. Is if we have an application that was denied for reasons that we think are inconsistent with the eligibility criteria, then we can appeal that. Transitioning into guardianships, as estate planners, the first level of planning for incapacity is the use of powers of attorney. So an example of incapacity is if I were to go out and to get into a car accident, suffer a traumatic brain injury, but I could still, you know, ambulate, move around, but I don't understand what contracts are anymore, anything like that. I'm essentially an incapacitated person, and it would be probably in my best interest to have a third party to step in and start making decisions for me. So really, in this incapacity planning world, we're talking about third parties making decisions for that incapacitated person. And the first round of that is, like I said, powers of attorney. And we've got two primary documents that we typically sign, and that's a healthcare power of attorney and a financial power of attorney. But a power of attorney is like a contract. You have to have the requisite mental capacity to understand what you're signing, what authority you're giving away, and who you're giving it to, and the scope of that authority that you're giving away. So it's really determined on a case-by-case basis, because I have some clients that come in and say, you know, my son or daughter just turned 18. Should we pursue guardianship? And then we have the discussion about, well, do you think that they can sign a power of attorney? We talk to their medical providers and ask them the same question. And they may be able to appoint an agent just by signing a power of attorney. Now, you know, that's the primary option, and it's a whole lot cheaper than pursuing guardianship as well, because if the principal cannot sign a power of attorney, then the backup option is to petition a court for guardianship. And we like to, if we can, we like to avoid guardianships because they are primarily, it's a court process where we're filing a petition in the county where the person resides, asking a judge to appoint the petitioner as a guardian of the ward. It's all, unless it's minors, it's all public record. We have to disclose family information. We have to disclose financial information. We have to disclose a description of the disability. And if we can avoid that, we would like to, but sometimes we just can't, just given the circumstances. So if we do proceed with the guardianship, then there are like powers of attorney, there are two types. There's guardian of the person, and there's guardian of the estate. Guardian of the person is going to be the one that makes the medical decisions, and guardian of the estate is going to be the person to make the medical decision, or excuse me, the financial decisions. For purposes of this presentation, the primary thing that we have to prove to the court is that the ward is an incapacitated person. And that term is actually defined in the code, and it is not a, there are no specific diagnoses listed or anything like that. And I'll just read the definition to you. It means a person who is impaired by reason of a disability such as mental illness, mental deficiency, physical illness, chronic use of drugs, or chronic intoxication to the extent of lacking sufficient understanding or capacity to make or communicate decisions to meet the essential requirements of his or her health or the safety of his or her estate. So a long definition to say that there is no specific diagnosis, and that will also be determined on a case-by-case basis. In addition to that definition, a minor is always an incapacitated person. Generally, we don't have to petition for guardianship of a minor because the parents are the natural guardian. Now, where we see minor guardianships is if the person is entitled to property that they cannot legally hold. So real estate, personal injury settlements, Social Security lump sums that come in from back pay, inheritances, just anything that is going to be. The guardianship code says that if the estate is below 5,000, then the guardian is not required to petition for guardian of the estate. What we find though is most banks and people, when you go to try to deposit, let's say a $4,000 check, they're going to say, you don't have the authority to do this. We need to see that you're appointed as guardian. And that's just, I feel like financial institutions try to cover themselves as much as possible, and that frequently translates into a tougher position with our clients. So let's see. If kind of getting closer to the age of 18, sometimes attorneys will petition for guardianship just based on minority alone, meaning, judge, we've got the situation with disabled children. I would say that it would be better to petition for minority and to give a description of the disability to the judge, because the guardianship code says that if a guardianship is in place because of minority only, meaning they're under the age of 18, that guardianship automatically terminates once the person turns 18. So If you show that the guardianship is for minority and a disability, then you can petition the court after the child turns 18 to ask the judge that the guardianship continue for good cause, i.e. the good cause being the disability that will last into adulthood. Okay, I think that's a 10,000 foot view of SSI and guardianships. Lindsay, let me know that we got about 8 minutes left on my portion, so we want to open it up to questions. I'd be happy to address.
You guys are welcome to either type a question in the chat or just go ahead and unmute and ask Trey directly.
Can we say it out loud or we write it in chat?
Andy, that's fine. You can talk out loud. Yeah.
It's a little easier for me. Okay, so I have a question about guardianship, power of attorney. I have guardianship of my son who is 24 and has Down syndrome and autism, so he's pretty profound. I don't need power of attorney on top of guardianship. I just need guardianship, correct?
Yeah, if you have guardianship already, then you are good to go. You are the decision maker for your son.
And does that make, I'm also the representative payee account for his bank account, and I'm legal being guardianship of doing that, correct?
Yes.
Okay.
Yeah. So the becoming rep payee is a little bit different process. You just essentially let Social Security know that this is an incapacitated person that needs to have his funds managed. So you will account to Social Security every year, and typically a court will not require you to account to the judge as well because you're already responsible to Social Security.
Right. Like I used to, every year I had to fill out a form around his birthday that says, you know, I controlled his funds and where it went, whatnot, and justified where that money went. But then a couple years, like 2 years ago, I got a letter that said we no longer had to justify to the court because I'm his biological mother.
So yeah, if you were getting that from the court, I find that most judges with disabled children and disabled adults, they want to make it as easy on the guardian as possible. So I have no issue with the judge telling you that. In fact, we try to encourage judges to do that, especially if the only income source is Social Security.
Okay. Thank you.
Trey, we have a chat question there from Dana.
Yeah, and can everybody see that?
Yeah,
Lindsay,
it went to everyone.
Okay. So if we file for guardianship based on disability, does that take care of person in the state, or are they separate guardianships? The petition will be for, it really just depends on if the ward has any assets. If the ward does have assets, then you would want to petition for guardianship of the person and the state. That way you have authority to make medical decisions and financial decisions over those assets. If the ward does not have any assets, then what we typically do is say, Judge, we're petitioning for guardianship of the person to make healthcare decisions, and we're also going to petition for guardian of a limited guardian of the estate to handle any financial decisions that may need to be made should those circumstances arise.
Okay, it looks like we've got another question about a co-guardian.
So is that coming through on the chat?
Yes, that our son became co-guardian this past summer. Any insights?
Okay. Generally, you can have co-guardians of the estate, but you cannot. So, you know, what typically happens is husband and wife become co-guardians of their son's estate, but you cannot have co-guardians of the person unless you are husband and wife. And that's just I think it's a holdover from the early versions of the guardianship statute. And I think it's directed more towards minors. So just be mindful of that. I made that mistake when I first started practicing. I tried to appoint sisters as co-guardians of the person of their mother. and the judge had to get on to me a little bit. So,
Oh, sorry, I didn't want to. I don't want to interrupt your question. Oh wait, we do have a. Let's see. In Illinois, they are co-guardians. My son plus mom and dad in court. Wendy, are you able to unmute? Maybe
Yes, I am. Can
Oh,
you
there
hear
you go.
me?
Okay.
Yeah, so we went through the same attorney that we had in Illinois. We relocated to Arkansas, but this past summer via Zoom, 6 minutes long, the judge appointed our son co-guardian.
okay, so how many co-guardians are there now? I'm sorry.
Yes, yes.
Is that in the state of Arkansas?
That's in the state of Illinois, and it just says of the person and estate.
So it's you and your son as co-guardians?
Our son and then mom and dad.
So is guardianship rules different from state to state?
They are different from state to state. And Wendy, what I will say to that is most states will honor another state's court order appointing a guardian. So without being familiar with that, the other state's guardianship rules and requirements for co-guardians, if the judge appointed the co-guardians, then there, you know, I think the biggest concern that not concern, but thing that I would want to know is whether or not they have to act by a majority or whether or not they can act independently. Obviously, acting by majority requires a little bit more steps than if they're able to just go do things on their own. But you know, the flip side of that is you better make sure that you trust all co-guardians if they can act independently.
Thank you.
I think Angie's got a good question there, and I was thinking this too. Can in the in the circumstances where maybe a guardian passes away, can the guardian name another guardian in a trust or a will or in some other capacity?
Yeah, so if it's a minor, the parent can list a nominated guardian in some type of writing. We typically put it in wills, but it can also be put in any type of writing that is authenticated, meaning we know that this person executed this document. Also, if it's a minor, if the guardian knows that their passing is imminent, then they can appoint what's called a standby guardian. And that standby guardian will come into office upon the person's passing. I think this rule needs to be changed to include adults as well, because the alternative for an adult is if the guardian passes away, then the guardianship code, and I think this probably needs to be changed too, says that the substitute guardian has to go through the same process as the original guardian. So you've got a petition, you've got to give notice, you've got to, most judges won't require new proof of incapacity, but it can be a drawn out process. And I recently went through that with a client, and practically most judges will say, we file our petition to substitute and we submit an order with it. And most of the time, the judge will just sign the order without requiring a hearing and all of that. Just practically, I think that's the right result. But you know, if you think that it's going to be challenged, or if you think that there are some issues with it, then you may want to go through all of the steps that you typically go through with a guardian. So all of that to say that the substituting a guardian in the adult phase is a bit of a cumbersome process. So Angie, what you would do in the special needs trust situation is you would just name a successor trustee. So if something happened to you, then the successor trustee would step in.
Thank you.
Trey, I guess we're at 10:32. So I just want to ask you a couple of questions that I think might be important to note is that guardianship, it does have to be renewed annually, correct? Or is that incorrect?
It does not have to be renewed annually, but you have annual reporting requirements.
Annual
So every
reporting
year,
requirements. Okay.
every year, the guardian of the person has to report where the person is living, how they're doing, and whether or not the incapacity is still there, and whether or not the guardianship is still necessary.
And
The
they have,
guardian,
oh, sorry, go ahead, Trey.
the guardian of the estate has to account yearly for the ward's assets.
Okay.
That are subject to guardianship. So let's say, just hypothetically, going back to my inheritance situation, I've had a couple kids who inherited things from their grandparents, and if parents are using the money for their benefit, then we've got to submit the bank statements every year to show what's coming in and what's going out.
If someone wanted to pursue guardianship, is it best to start before the child turns 18, or must you wait until the child turns 18?
If it's a disabled child, then I think it would be better to petition. Color and I disagree on this, but I think it's better to petition before the child turns 18. That way you don't have a gap in decision-making authority, because sometimes, if the child's still in school and they turn 18, then the school says, we're not going to give you any information because the child's an adult now. And other third parties may push back because the child is now an adult and they're entitled to certain rights.
Right.
So I recommend doing it before 18, but not, we can do it at 17 and a half or whatever. Just as long as we have a guardianship in place before 18, we can always come back and ask the court to continue it for good cause because of the disability.
Okay. All right.
I have a question. I have a couple of questions.
Yeah, go ahead, Monique.
Hi, good morning. This is Monique Jones. My first question is, you started talking about power of attorneys. What's the benefit of having a power of attorney going into 18? Does it hold the same weight of the guardianship? Do I need a guardianship if I'm the custodial parent? Do I need a power of attorney if I'm the custodial parent?
You are the natural guardian of your minor children, so you should be able to conduct business on their behalf as their parent. A minor cannot sign a power of attorney. So the question then becomes, once they turn 18, do they have the requisite mental capacity to sign a power of attorney? And that's going to be a conversation with your child, with the child's medical provider, and with an attorney to all determine or look at the circumstances to see if the child has capacity to do so. If they do not, then your backup option is to petition for guardianship, so you can be appointed as the decision maker for your child.
And that's where you're saying to be careful getting closer to 18, to petition for that guardianship before 18, so you don't have to run into that. I guess my next question, going back to, you started out also talking about the Social Security benefits. So it almost seems as if there's a deterrent of inclusion and allowing them to live an inclusive life to be able to make earnings, therefore their Social Security will be cut. Is that correct?
Yes, I think that if they are able to work, then that income is going to be counted against their resources, against their SSI benefit. So you want to balance that, balance their ability to work against their ability to receive that SSI benefit.
Okay, thank you.
All right. Well, we better move on. I know there's so many more questions and so many. This is like Trey said, this is a 10,000 foot view. But let's go ahead and move to Katie. Katie, I'm gonna spotlight you here. Let Katie dive in. Tell us a little bit about yourself and some special needs trust, and we'll do some more Q&A. So Take it away.
Okay. Hi, I'm Katie Eves. I'm currently a partner at Friday Eldridge and Clark. It is a larger law firm in the area. We're kind of throughout the state, but I'm located in Rogers. I went to the University of Arkansas for law school, and then I went to get my tax degree. So I have a master's in tax law from the University of Florida. And so I actually specialize my practice. You're not really supposed to say that, but I focus my practice in primarily just estate planning and taxable issues, people who have income tax issues, but also people with estate tax issues. So I kind of focus more on the tax side of things and the estate planning side of things. I do the occasional guardianship. I try to stay away from that a little bit, but I definitely have more guardianships in situations that I think are similar to most of you guys, where there is a child with special needs that would be turning 18, becoming an adult, and would need some sort of guardianship. So I do a few of those here and there, but primarily I do a lot of trusts, primarily big estate planning type trusts, where we're focusing on not just the estate plan, but also special needs planning. I don't do as many standalone special needs trusts, but the occasional one will come across my desk. So that is sort of what I do. Thank you guys for having me, and please feel free to interrupt me throughout this pseudo presentation and ask whatever questions you would like to ask. I kind of want to start with something that Trey already kind of talked about, which was the powers of attorney. And I kind of want to just go back to that a little bit more. So there's a couple things that you guys need to think about. A guardianship may not always be necessary, as Trey had mentioned, may not be necessary. So if your child with special needs has mental capacity to sign a document, so legal capacity to sign a document, then you might not need guardianship. Sometimes it's easier. A lot of like banks and other people that you're working with will prefer to handle a guardianship. Will prefer you to have a guardianship than have just a power of attorney, especially when we're dealing with somebody with special needs. But it just depends on what you need. If your child, though, has the ability to sign a legal document, then a power of attorney is by far the easier way about going about things. One of the questions on there that I don't think you guys got to on this chat box was, how long does it typically take to execute a guardianship? That could take a long time or a short time. That's probably not the answer that you want to hear. But sometimes we have guardianships, and typically, and I would assume in most situations similar to you guys, when we have a child with special needs, and it's clear that we need a guardianship, they don't have the power to sign a document, a legal document, and we need to do a guardianship, then we're going to need to be able to say, let's move forward with getting a guardianship. The judge typically will understand what's going on, and it shouldn't take too long. I would say most of the time you would be able to get something, at least a temporary guardianship, set up very quickly, typically within about a month or so. And then the permanent guardianship would follow. That could take anywhere from, I would say, like 1 to 3 months-ish. It just depends on how quickly you can get somebody to say that this person is incapacitated, and how quickly we can get the judge to put you on the docket, really. That's kind of how quick it is. I heard somebody earlier say that they had obtained a guardianship in Illinois, and it took about a 6-minute Zoom call. If there's no one contesting the guardianship and there's not multiple people trying to become guardian, and it's clear that this individual is incapacitated, they do typically take about 6 minutes. It's a quick and painless process. It's just still a process. So we have to, prepare all the documents, get everything filed, make sure that we have a doctor that says that this person is incapacitated, and move forward. So, but like I said, if your child technically has legal capacity to sign a document, then the power of attorney might be a better and easier, at least, option. One thing, though, is I agree with Trey that if your child has special needs and you need to get a guardianship established before they are 18 so that they can, you won't have any lapse in guardian, in power over their assets and their healthcare decisions and things. I agree, you should do that before. You cannot, however, sign a power of attorney until you have capacity to do so. So that means you are technically 18. So you have to be not a minor anymore, plus have mental capacity to sign the document. So just kind of a little nuance, you might need to wait until your child is 18 to be able to sign that if they have the power to sign it at that point. If not, the guardianship is your only option. So let's talk about some estate planning in general. Has anyone here dealt with probate before? It's not, maybe it's not a fun process either.
But not personally.
Okay, it's not a fun process to deal with. It's not the end of the world either, but it's not a fun process. So in general, estate planning is, preparing your assets and where they should go after you die, right? It's a pretty easy thing. I'm just getting to the actual special needs trust. So I'm trying to kind of set it up for you guys. So estate planning in general is just preparing to make sure that all your assets goes to the right person, right? There's a couple of ways you can do this. A lot of people will have what's called a last will and testament, or just a will. Your will is basically indicating who you want your assets and your stuff to go to upon your death. So not maybe just like your actual heirlooms, your stuff, but maybe your bank accounts and everything else. When you have a will, your assets pass through probate. Probate is basically the court is administering the estate to make sure that the right people are getting the assets in the right manner. So that's what probate is. It's a court process. In your will, I have seen this before. So if you have guardianship over your adult child and you have a will, you could at least, now it's not technically allowed per se in the statute, but I've seen this happen where the court has looked at that individual's will to see you have appointed somebody else. You have basically specified who you would want to take over that the guardianship of your adult child in your will. So you might want to at least indicate that somewhere in your will, showing who you would want to appoint as guardian if something happens to you. So it's a good document to talk about having, is at least something that specifies that. So there's that. Then the other thing you can do is what's called a trust. There's multiple different types of trusts. I draft all sorts of trusts. So there's irrevocable trusts that you could create for certain tax benefits. And then most people have what's called a revocable trust for basic estate planning purposes. If you have a trust, most people will have that.
Repeat those two one more time.
So there's an irrevocable trust for estate tax purposes. You probably don't need to do a lot of that planning. You could if you wanted to, but most people don't have those. The revocable trust, which means you can make changes to it during your lifetime, could be for general estate planning purposes. So all my assets are going to be distributed through this trust. The benefits of the trust are, one, it is effective now. So if you become incapacitated, your assets are in trust. The person you name as a successor can step in and act on your behalf if you become incapacitated. Two, if you effectively transfer your assets to the trust while you're alive, then the trust itself will avoid probate. So all the assets in the trust will not go through that probate court process. And number three, the most important thing, especially for you guys, is to be able to retain some control over these assets. So if we need to hold back some of the assets for, kids in general. So for example, I have a 3-year-old and a 6-month-old, so babies, and they have no idea what estate planning is. They don't know what money is. They don't know what accounts are, and they have no business having access to anything. So if I were to pass away, my husband and I were to pass away, we have a trust set up so that all of our assets are held for their benefit. Okay, so it will continue to manage. Somebody who I've named in the trust as the successor trustee will manage those assets for their benefit, make sure they have what they need, will pay out what they need, et cetera, right? So that's kind of the basic planning. A lot of my trusts, however, when I am preparing trusts for people with children with special needs, adult or minor children with special needs, we can build in special needs trust provisions into that trust. And the way that that works is it's basically saying, we understand that our child potentially could be on governmental benefits of some sort. So SSI or SSD or some other governmental benefits that they are receiving. We don't want to mess that up for them. And we want to make sure that they are going to keep getting those benefits. Okay, so this is going to be separate from a guardianship or power of attorney that you would have over the child, meaning you're still going to be managing their benefits they're receiving from Social Security and every other avenue that they're receiving benefits. You're going to continue to manage those as guardian or otherwise. And whoever the successor is would continue to manage that. But there's this separate entity, which is the trust. And the trust is going to manage whatever assets I'm going to give. So if I have a child with special needs, I would build in that special needs trust language so that my child receiving governmental benefits over here will continue to receive those benefits and continue to have that. But over here, we're going to supplement that's really what we're doing, is we're supplementing whatever they might need that over here is not going to pay for. Because most of you understand that the stuff that's over here with the governmental benefits is not all encompassing. It most of the time does not cover everything that they might need. So I want to make sure that couple things. One, I don't want them to lose their governmental benefits. Okay. And two, I want to make sure that they have anything that they need. So this is a supplement to this. So the special needs trust in general, you can have a couple different ways. Like I said, there's the revocable trust, which is just my typical estate planning document, right? That says, here's what you do. Here's how I want things distributed upon my death. But it can also build in that special needs trust language. Or you can have a standalone special needs trust itself, which is just for the benefit of that child. It depends on what you would want to do. I don't do very many standalone special needs trusts because most people like to build it into their own estate planning. If they're going to get anything done, they'll just get it all done at the same time. So most of the people prefer that. But something that Trey had mentioned before about the in-kind maintenance and support, that is basically saying we can't have this trust over here paying too much to the beneficiary to the point where it would kick them out of receiving governmental benefits. So the special needs trust has to have very specific language to say, you can only get this much, not really this much, but it's limited to this, the language is limited to what they can and can't have. And that's how we ultimately make sure that they don't lose their governmental benefits. So that is an option. One of the other things I saw you guys had a few questions on was the ABLE account. I'll get to that in a second. I'll answer this question from Angie. How does the beneficiary work with a special needs trust? The beneficiary that you would name would be, your child that has special needs. So the trust, it depends on how you want to structure the trust. So if you have a standalone special needs trust without the other estate planning part of it, that beneficiary would become a beneficiary whenever you want them to become a beneficiary, but most people it's effective immediately. They become the beneficiary now. And so you're the trustee and you can continue to manage it for their benefit now. I don't typically see that a lot because your assets are your assets and not your child's assets. And so the government can't, when your child's an adult, the government is not going to be trying to tell you how you can and cannot manage your own assets anyways. So in the revocable trust context, the beneficiary only becomes a beneficiary upon your death typically. So when you die, then it's funded into this trust. So your successor trustee is managing it for their benefit. But they will be the only beneficiary while they are alive. So then you can in the trust provisions, specify what you want to happen to those assets upon their death, so upon the beneficiary's death, where those assets would go, if there's anything left. You can specify that as well. Wendy, when should the special needs trust be funded? It depends on if you do the revocable trust or if you do the special needs standalone trust. If you're going to try to do a standalone trust, it should be funded immediately. Like I said before, most people don't do those standalones because honestly, it's just your money anyway. So you can continue to hold it and manage it how you want to and distribute what you need to your child with special needs. But the revocable trust, it should be funded while you're alive. So don't die before you fund it. That's the point of just avoiding probate in general and having to avoid going to court. So that's kind of how that works. Let's talk about ABLE accounts for just a minute, and then we can kind of go through some other questions. The ABLE account came up a few, oh gosh, I say a few, it was probably like a decade ago that ABLE accounts came around. Many of you have probably heard of the 529 accounts. It's like setting up an account for your children or for other children in general for educational purposes. It's very similar to the 529 account. In Arkansas, you can get an income tax deduction for some of your contributions to an ABLE account, which is specified for a beneficiary with special needs. You have to meet, that beneficiary has to meet some tests of what those special needs would include. And so you have to kind of look through those rules and regulations to make sure that they qualify, but they're different than the SSI qualifications, I believe. They might be relatively similar, but I have not set up very many ABLE accounts because typically financial advisors are the ones who set up those accounts. And there might be a program specifically with the state of Arkansas that handles that. But it's basically a way that we can put a bunch of money into an account, it can continue to grow, and it can basically act like a special needs trust. The benefit of that over the special needs trust is it's a lot easier to set up and maintain. The downside is you're limited to about $100,000 in there. So you're going to create some issues with governmental benefits, your SSI qualifications if you exceed the $100,000. So I still think it is 100,000. It's been a couple of years since I've looked at those, but I'm pretty sure it's 100,000. So it's a nice thing too, that you could have maybe a nice rich relative provide some money into an ABLE account for your child with special needs. And so it's an easier thing to manage. You don't really have to manage it. You don't have to deal with trust returns, income tax returns. You don't have to deal with anything like that. So that's kind of the benefit of the ABLE account and the burden of the ABLE account. It's limited is the burden. Some of the questions, can your pensions or 401k be left to your adult? They can. If your adult child has special needs and is receiving governmental benefits, you will then potentially cause them to release their benefits. They'll no longer be entitled to them. So that's going to be a potential problem. If you have a problem like that, a special needs trust is your best option because you can name the trust itself as the beneficiary of your 401k instead of the child, which would then ruin their governmental benefits qualifications. Pensions, on the other hand, though, pensions are typically accounts that will die with you. So you have to check to see if they will ultimately be able to transfer post-death. Special needs trusts are transferable from state to state. So Arkansas has what's called the Arkansas Trust Code. It is what governs what trusts we can and cannot have and how they're managed and what they do in Arkansas. Most states have codes similar to Arkansas's. Some states don't have the Uniform Trust Code, which is what we have, but every state has a trust code and it's very similar. Most of them are very similar to Arkansas. So yes, you can transfer them. That is not a problem. The ABLE, I think, does go to the state after the beneficiary dies. Unless I think you might be able to pick another potential beneficiary, special needs beneficiary, but I'm not positive. I think you are right, though. I think that the benefits go to the state after death. Whereas the special needs trust, you don't have to do that. You can name a different beneficiary. So, any other questions for me? That was really quick.
I'm going to throw out a question, and it could be for either you or Trey, but if someone was wanting to start the guardianship process And they may be like, I have no idea where to go or what to do, or, you know, so give some advice on that. Where do people need to go start?
So in my opinion, it's good to start with talking to an attorney that handles guardianships, just to give them the idea. Not to every 2 guardianships are the same. There's always something else that would be a factor that you just need to talk to an attorney about and get advice on how to get the guardianship started. So that's what I would say. Start with an attorney.
Yeah, I second that too, because it's going to be a case by case basis. And I think, you know, we do free consultations. I don't know if how else it is. And I think most other NWA firms do that as well. So you can get a good idea, and you don't have to make the decision right there in the office. I tell most clients, hey, take your time, think about it. And as long as an emergency doesn't arise, then you've got some time to think about it.
Okay, we have just a few minutes left. Does anybody have any questions you just really want to get answered? Why we have 2 experts here to helpfully assist with that.
Yeah, I have one. Who's the best person to speak to regarding different accounts? Because my understanding from where we used to live in Illinois, a 401k is taxed different than a regular bank account, taxed different than a trust, taxed differently. And so we moved from Illinois. We need to reassign our beneficiaries so that we can minimize the amount of taxable income if one of us were to pass away.
Tax. That's a whole, that's a lot of time to answer that question.
I saved the best for last.
So let me give you the speed version. Okay, so retirement accounts are now subject to what's called the Secure Act. It came around about a year ago, a little over a year ago. Beneficiaries in the Secure Act for retirement accounts are only entitled to a 10-year payout post-death, meaning you have to pay income tax on all of the retirement fund within 10 years, except for people with special needs. So that's one of the beneficiaries that is entitled to basically like a rollover type retirement account. So there's that. You can make that an option. On changing your beneficiaries, it just depends on what your overall estate plan is, which is not really an answer for you, but I'd have to look and see what your estate plan looked like for me to kind of give you the.
Okay, I'll be making an appointment because we got everything set up in Illinois, but my guess is Arkansas has different state laws or tax laws. So we just want to.
Arkansas does not have estate tax laws like Illinois does, so I'll just mention that. There's not an issue for estate taxes in Arkansas.
Dealing with those qualified retirement accounts, it's going to be the same. Those are governed by federal law, so it's going to be the same application from just about state to state.
Thank you.
All right, looks like we have a question from a couple of different people here in the chat. Carly had a question that they have, well, their daughter's only 2, but you know, their grandparents are asking about inheritance. To go ahead and set up the trust now is the question, I guess.
Yeah,
I am an advocate for trusts, so yes.
that's one way to avoid a guardianship as well, is if you can set up a trust that leaves a share to a minor beneficiary, but that share can be held in trust until the minor reaches a certain age. And you can be creative with that as well. So if you know, most folks are waiting until 25 or 30 before the entire principal, the amount, the share is available to the beneficiary.
Typically, what does it cost to have a special needs trust? Like, what does it cost to file for it? And
Yeah, so
You're not gonna like this answer, but it depends.
yeah, so it's like the guardianship answer. It's really just a case by case basis. How many beneficiaries you want to include, if it's a first party versus a third party special needs trust. So I would, again, just kind of going back to the guardianship answer, go talk to an attorney. We do most of our estate planning and trust on flat fees, so it's not, you know what it's going to be versus trying to calculate what the hours are going to be that go into it.
And typically, how long does it take to get that into effect? Or is that also vary?
I mean, it's just as quick as the attorney can draft it and the person that's setting it up can sign it.
Thank you.
I had a question here from Dana about revising a guardianship at a later date to maybe assign a younger child who's not of age yet, but would be at some point in the future.
Yeah, I would definitely look into that. You could petition the court at some point during the guardianship to let them know that you are no longer able and willing to be the guardian, or you don't feel comfortable. And, you know, ultimately the judges are people. And so they understand that that is a need. And so if you just petition the court with an attorney to say, you know, I've been the guardianship for this amount of time, I feel like I'm not eligible to become the guardian anymore. And I would like to, and this so-and-so person is petitioning the court to become the new guardian. The court would understand that and most likely just be fine with it. It just takes going back to court.
All right, thank you
Yeah,
guys.
and a guardianship is going to last until the ward passes away, or until the ward proves that they're no longer an incapacitated person. So, you know, as long as that person is still suffering from a disability, you know, it's probably going to need to stay in court with somebody there acting as a decision maker, because if it's an adult, and I told you guys earlier that I did a lot of APS cases. The first level we talked about was powers of attorney. If you don't have that, then your backup is guardianship. If there's no family member or other person to serve as guardian, then APS could get involved if the person is an endangered adult. So that's kind of the breakdown of incapacity situations.
All right. Well, thank you guys so much for your time. You know, I'll make a personal note here that my son turned 18 last year, and we waffled around on what we were going to do. And so, you know, there was that gap period, I guess. We ended up doing a power of attorney. I decided that was the best option for us. But there was an incident where we had to go get a COVID test. And because he was 18, they wouldn't let me go with him. So, you know, like, I would just advise everyone to be thinking about this before you get to that point, and then you're faced with a situation which that wasn't that serious. But I mean, like, you know, it could have been a serious situation in which I wouldn't have had any legal control or medical control, or you know, so just be prepping before they get to 18. So. But all right, well, we'll be respectful of your time here, and thank you guys. I know this was a lot of information to take in, and there's a lot out there. So hopefully everyone took something away from this and can follow up on some things. So thank you guys for your time. We greatly
Thank you.
Yeah.
Yeah, thank you. It was wonderful.
Thank you.
Thank you. All right, everyone have a great weekend.
Thanks, guys. Bye.
Thank you. Bye-bye.